As always, those who ask to be heard by the court offer their arguments first. Noel Francisco argued on behalf of Smith & Wesson.
Mr. Chief Justice, and may it please the court. Mexico asserts that American firearms companies are responsible for cartel violence ravaging Mexico. Its theory is that federally licensed manufacturers sell firearms to licensed distributors, who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers, who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money. Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act.
The Protection of Lawful Commerce in Arms Act, 15 U.S.C. Chapter 105, was created to protect gun manufacturers from nuisance lawsuits claiming liability for the misuse of their legally produced and sold firearms. Holding Smith & Wesson responsible for the actions of those 5 layers of abstraction away would seem to fit that description. There are, however, exceptions to the immunity from civil liability, including, in general, the term qualified civil liability action means a civil action or proceeding or an administrative proceeding brought by any party against a manufacturer or seller of a qualified product, but shall not include an action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product, and the violation was a proximate cause of the harm for which the relief is sought. This is where the question of proximate cause enters in. This is important since a significant amount of the arguments revolve around this question.
As to proximate cause, this court has repeatedly said there must be a direct relationship between the defendant's conduct and the plaintiff's injury. But no such relationship exists if plaintiff's injury is caused by multiple intervening independent crimes committed by foreign criminals on foreign soil to inflict harm on a foreign sovereign.
Now, here's the first problem for Mexico's case. The alleged relationship between Smith & Wesson and the harm to Mexico is separated by numerous intervening actors, only some of which are committing crimes, many of which are committed in Mexico, not the United States.
As to aiding and abetting, Mexico doesn't identify a specific crime, criminal, or criminal enterprise that defendants supposedly helped. Instead, it asserts that defendants are liable for every illegal sale by every retailer in America because they know that a small percentage of firearms are sold illegally and don't do more to stop it.
That's not exactly what Mexico is alleging, but remember, these are lawyers arguing a case for their clients. Before we go on, we should remember one thing. What is aiding and abetting? Well, according to the Free Legal Dictionary, to aid someone is to help or assist, while abetting is to approve, encourage, and support. So for this case to be eligible for this Placket exception, Mexico must show that Smith & Wesson assisted, approved, and or supported the crimes committed in getting their products into the hands of the cartel. Seems a pretty tall order to me.
Again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash.
Again, the liability for how a product is used or abused once it is out of the control of the manufacturer does not survive the common sense test.
The First Circuit gravely erred in embracing that implausible theory and should be reversed. I welcome your questions.
Before we get to questions, let's hear from the other side of this case.